Okay, Ms. Miller, can you unmute, please? All right, are you able to hear me okay?
Yes, sir.
Okay. We're on the record in People versus Alexis Miller, case number 234787. The record should reflect Ms. Miller's present today by Zoom. If I could have counsel put your appearances on.
Ryan Ziegler, okay.
Thomas Seeger appearing with and on behalf of Ms. Miller.
This is set for a final status conference today. We do have a trial date set for December 19th. So this is a date for final status conference and plea cutoff. Mr. Seeger, does your client still wish to proceed to trial in this?
Your Honor, an amended offer has been extended wherein Ms. Miller could plead to an added count 2 of possession of analogs, which is a 2-year felony. In exchange, count 1 and the habitual offender 4th notice would be dismissed. I did have discussions with Ms. Miller relative to whether or not she wishes to accept this plea, and I will defer to her decision, but I would encourage her to accept the plea.
All right, Ms. Miller, were you able to hear that?
Yes, sir.
Okay, how did you want to go forward today?
I want to proceed to trial.
Okay, I just want to make sure that you're clear that this would be the last day for you to enter a plea to any lesser charges. Do you understand that?
Yes, sir.
Okay, so if Mr. Seeger calls the court tomorrow or next week or the day before trial and says that you want to accept the plea agreement, the answer is going to be no. Do you understand that? So you're not going to be able to change your mind after today.
Yes, sir. I understand.
Okay, so we'll proceed with trial as scheduled on December 19th. And Mr. Ziegler, from the people's standpoint, are there any issues, pretrial issues that we're going to need to address prior to jury selection?
No, Your Honor.
Mr. Seeger?
No, Your Honor.
Okay, and we have the set for a one-day trial, is that correct? Yeah, one-day jury trial. Okay, so Ms. Miller, you need to be here at 8:30 at the latest on the morning of December 19th. It's a good idea for you to stay in touch with Mr. Seeger prior to the trial date so that you're prepared to go forward with trial that morning, okay?
Yes, sir.
Your Honor, and I understand what the court said, and I explained much the same as the court just explained to Ms. Miller. I don't know if you have time in the docket again today to conceivably revisit things to the extent that she changes her mind, which I'm not saying that she will. But if I had another additional opportunity to express some things to her again, maybe she will. If she doesn't, that's fine. We just never come back.
Yeah,
Until
okay.
trial.
Yep, I'm here till the end of the day today. So.
Thank you, Your Honor.
All right, I'll just ask Mr. Ziegler, as usual, that you submit a full text copy of your proposed jury instructions and verdict form. Mr. Seeger, if you can just indicate whether you have any objections, and if you do, what the objections are and any additional instructions you want to request. Anything else we need to address, Mr. Ziegler?
No, Your Honor.
Mr. Seeger?
No, sir.
Ms. Miller, did you have any questions at all?
No, Your Honor.
Okay, we'll see you at 8:30 a.m. on the morning of December 19th, and you're free to disconnect.
Thank you.
I'm not sure who this is. Mr. Seeger, do you recognize that?
That's Ms. Keeley, Your Honor.
All right, Ms. Keeley, we need you to connect your audio on your Zoom app. We did have another matter scheduled at 9 AM, Gregory Smith.
And he's lodged in Wexford, Your Honor.
Okay.
Was she unable to log in, Your Honor?
I think she didn't connect her audio, so I sent a message to her to connect her audio. It's like that's maybe what she's working on.
I sent her a text, so she said she's trying.
Okay, looks like Wexford just signed in, so we can grab Mr. Smith's case.
There you go, sir.
All right, sir, is your name Gregory Smith?
Yeah.
Okay, we're on the record in People versus Gregory Smith. This is case number 234849. The record should reflect Mr. Smith is present today by video from Wexford County Jail. If I could have counsel put your appearances on in this file.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger, appearing with an on behalf of Mr. Smith.
Thank you. Mr. Seeger, this looks like this is Mr. Smith's first appearance before Circuit Court on this file. Can you tell me where things are at here, Smith?
Your Honor, I've had discussions with the prosecuting attorney's office. However, there were some pending matters in other counties for which the police report someone encapsulated. In any event, I've spoken to Mr. Atwood, and then they recently reached out to Wexford County to determine what they were doing there. In any event, my understanding is in Grand Traverse County that they would consider some kind of global resolution. I'm not sure what Wexford County will do, Your Honor, but if the court gave me an additional 30 days, I did talk to Mr. Kane, who is his counsel in Grand Traverse County. And so hopefully I'll be able to work out some kind of potential resolution when or another the court gives me an additional 30 days.
Okay, Mr. Ziegler, do you have any objection to that?
No, Your Honor, I think it's appropriate to pursue a global resolution in this matter.
All right, Mr. Smith, were you able to hear that?
Yes,
Do you have any objection to the court setting this over for another 30 days to give Mr. Seeger a chance to work with your other attorneys and see if you can get everything resolved?
no, that's fine with me.
Okay, so the court will set this for a status conference or plea hearing in December. Mr. Ziegler, anything further we need to address from the people's side?
No, Your Honor.
Mr. Seeger.
No, Your Honor.
Mr. Smith, did you have any questions about how we're going to go forward from today?
No, I don't.
Okay, thank you. That's all for today.
Thank you.
Your Honor, Ms. Keeley has responded and indicating that she's having a hard time logging in for whatever reason. I was just gonna ask for an adjournment. I don't know if you need her to appear for that. She clearly did attempt to appear.
Well, it looks like she's trying to connect again, so let's try it one more time. Okay, Miss Keeley, you just need to unmute now.
Okay, are we good?
Yes, are you able to hear me okay?
I can hear you now, yes.
Okay, thank you. So we're on the record now in People versus Jennifer Keeley, case number 234851. The record should reflect Miss Keeley's present today by Zoom video. If I could have counsel with your appearances on the record.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with on behalf of Ms. Keeley.
All right, Mr. Seeger, how did we want to proceed on this file today?
Your Honor, I would just ask the court to give us an additional jury status conference. I'm confident that we'll be able to resolve the file one way or another. I have had extensive discussions with the prosecuting attorney's office together with the client. And I think that we'll be able to resolve it. We just need a little bit more time.
Mr. Ziegler?
I have no objection to the adjournment, Your Honor.
Ms. Keeley, were you able to hear all of that?
Yes, I was, Your Honor.
Do you have any objection to the court setting this over to give Mr. Seeger an additional period of time to negotiate on your behalf?
Yep, nope, thank you. Yep, that's fine, thank you.
All right, so I'll set this for a status conference plea hearing in 30 days. I am going to make that the plea cutoff. So Ms. Keeley, between now and that next hearing, you need to make sure that you stay in touch with Mr. Seeger and be ready with a decision as to whether you want to enter into any plea agreements or proceed to trial at that next hearing, okay?
Okay, thank you, yes.
Okay, Mr. Ziegler, anything further on this case today?
No, Your Honor.
Mr. Seeger?
No, sir.
Okay. Mrs. Keeley, did you have any questions?
I do not, thank you.
Okay, that's all for today, and you're free to disconnect at this time.
Thank you.
Mr. Seeger, Mr. Ziegler, do either of you know where Mr. Inman is located?
He's in Wexford County Jail.
Yes, okay.
That's 4854.
Correct.
This is Mr. Inman, Your Honor.
Okay. Sir, is your name Joshua Inman?
Yes, Your Honor.
Okay, we're on the record in People versus Joshua Inman. This is case number 234853 and 4854. The record should reflect Mr. Inman's appearing today by video from Wexford County. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with on behalf of Mr. Inman.
Mr. Seeger, where are we at with these two files?
Your Honor, my understanding is that Mr. Inman wishes to tender a plea. It's further my understanding that in 4853, he would plead to an added count 2 of assault and battery. In exchange, count 1 and the third offense notice would be dismissed. And that's, I'm sorry. Yes, and then in 4854, he would plead to an added count 2 of attempted domestic violence third. In exchange, count 1 would be dismissed.
Okay, Mr. Ziegler, is that an accurate statement of the plea offer?
It is, Your Honor.
Mr. Inman, were you able to hear all of that?
Yes, Your Honor.
And is that how you want to proceed today?
Yes, Your Honor.
Have you had adequate opportunity to discuss this plea agreement with Mr. Seeger before making that decision?
Yes, Your Honor.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. You can lower your hand. And Mr. Inman, are you currently on any kind of probation or parole?
No, Your Honor.
All right, and in count 234853, you're going to be pleading guilty to 1 count of misdemeanor assault and battery, and in exchange for that, the domestic violence 3rd will be dismissed. The maximum possible penalty you can face for assault and battery is up to 93 days in jail and or a $500 fine. Do you understand that?
Yes, Your Honor.
And then in file 234854, you're pleading guilty to an attempted domestic violence 3rd. As an attempt, the maximum possible penalty you could face for that charge is up to 2.5 years. Do you understand that?
Yes, Your Honor.
With all of those penalties in mind, what is your plea to each of those charges today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to appeal it, you'd have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to enter these pleas today?
Yes, Your Honor.
Are you pleading guilty to each of these crimes because you are guilty?
Yes, Your Honor.
The first one, file 24853, that indicates that's the one that involves Mr. Grady, and that this indicates that happened on June 7th, back in 2022. Is that the correct date?
Yes, Your Honor.
Okay. On that date, did you have an altercation with Gregory Grady?
Yes, Your Honor.
Where did that take place?
It took place at his house. I would just like to say that, I'm not disputing anything. I do know that was a last year thing, and that person that I'm not today. I had drank alcohol. I was under the influence of alcohol, and like the person I am today, I have changed. I did do it. I committed the crime. I just would like to apologize and just let the courts know that I have taken a lot of steps to my early. I've even have an early recovery skill group handout that I've been working on. I've been reading a lot of the Bible. I've read a book, I Don't Want to Talk About It, and another book called Jesus versus Drugs. I have taken a lot of steps to my recovery, and I'm hoping to get into some treatment So that on that date, I was under the influence of alcohol, and that I believe is what had caused me to do the things that I have done. And I'm realizing.
All right, let me just, I'm just gonna stop you for a second. You're gonna have a chance at the sentencing hearing to tell me about all of those kind of things.
Okay, I'm sorry.
Today, I'm just trying to get your testimony as to what actually happened. So this happened at his house. Is his house located here in Kalkaska County?
I think it is a Kalkaska, but it was somewhere in between Kalkaska and Fife Lake. I don't have his address on the top of my head, but it's I think it was a Fife Lake address, because that's when I was at the time I was working, my boss was at Fife Lake, so he was pretty easy for him to pick me up at that time or whatever. So my former boss.
All right. And did you have some kind of fight, or did you in any way touch or assault Mr. Grady during that incident?
I had shoved him, yes.
Okay. All right. And then the other incident we're talking about is a little bit later on June 22nd of 2022, and that involved Caleb Inman. Do you recall that incident?
Yes, Your Honor.
All right. And did that also take place in Kalkaska County?
Yes, Your Honor.
And is Caleb Inman somebody that you resided with, or at one point did reside with?
At one point, yes, Your Honor, I did.
Okay. And did you have some kind of altercation with him as well?
Yes, Your Honor.
All right. Was that physical? Did you have physical contact with him?
I guess you could call it physical, yes. I had shoved him too because of him and his sister were arguing, but yes, Your Honor, yes.
All right. Had you previously been convicted of let's see, of a domestic assault back in 2006, in March of 2006?
I looked at the dates. I guess I was. I don't really quite remember it, but yes, I don't want to deny it. But 2006, I was kind of confused on where I was at that time. I think I was here in Michigan, in Kalkaska, but I pled guilty to it because at the time I was incarcerated for a DUI, and I couldn't get work release at that time, so I pled guilty to it. I can't remember the whole incident, but I'm assuming I did. Obviously, I pled guilty to it, so yes.
All right. And then also same type of crime back in September of 2018?
Yes, and that was another one that said the person was pregnant, and I didn't have a baby at that time. There was nobody I even knew that was pregnant, but I guess I pled guilty to that too, so.
Okay. All right, thank you. Mr. Ziegler, are the people satisfied with the factual basis?
Your Honor, perhaps I missed it, but I don't recall the court inquiring as to the second incident where it took place.
I did, and he did indicate Kalkaska County.
Thank you. Okay.
Mr. Seeger.
Your Honor, just to clarify, Mr. Grady was formerly a roommate of yours, is that correct?
Yes.
No further questions.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger.
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger.
Yes, sir.
All right, Mr. Inman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these crimes. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing, and you're going to be contacted by somebody from the probation department for a pre-sentence report. Mr. Ziegler, do you have the fact code for A and B charge?
Yeah, 750.81.
Thank you. Mr. Seeger, anything further?
Your Honor, the only other request, just in speaking with Mr. Inman, was relative to whether or not the court would allow him to be released on bond so that he could get into treatment. Previously, he had conceivably that available to him. I did speak with the complaining witnesses, mother, at least in one of the files, who indicated that she believes him the larger problem to be with Mr. Inman to be alcohol related, which he did reveal to you that he previously had a DUI, so I can't believe that he has a substance abuse problem. He has expressed to me while he's been incarcerated that he's been working on finding tools to maintain his sobriety when he's released, and he's hopeful that he'll be able to get into a situation where he can address it. So the only question was whether or not, if he's able to get into a bed, if the court would allow him to be released for that reason.
So Mr. Inman, I've heard what your lawyers had to say. The court, I certainly would consider treatment as part of your sentence, but I think we need to get through that sentencing phase. But that's something that I certainly would be open to as part of your sentencing, okay?
All right, thank you.
All right. Thank you. That's all for today, and the court's going to disconnect at this time.
All right, thank you, Your Honor.
Do you need a minute to talk to Mr. Waganshoots?
No, Your Honor. I'm off.
Mr.
Unless you
Waganshoots?
need to.
This is case number 234842 and 4843, People versus Waganshoots, case number, I'm sorry, counsel can, so you can go right up to the podium there. Counsel, if you can put your appearances on.
Ryan Ziegler on behalf of people.
Thomas Seeger appearing with and on behalf of Mr. Waganshoots.
This is the date and time set for a sentencing hearing, and Mr. Waganshoots, have you had a chance to go through the pre-sentence report and speak to Mr. Seeger about that?
Yes, Your Honor.
Okay. And Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
Your Honor, on the face sheet under plea agreement, it says dismiss counts 2 through 5 for the first file. Should be counts 1 through 5. Defendant under his plea count 6.
Okay. Court order that correction be made. Any other corrections?
No, Your Honor.
Are there any challenges to the guidelines from the people?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, this was a drug bust at a house. The defendant did have a significant amount of various kinds of drugs in the residence. However, he is a young man. He has not had any prior felony history to this point. The defense counsel and I talked a lot about how to resolve these matters. I believe, and I continue to believe, that the agreement that we reached for 7411 on the one file and Haida on the other file is appropriate. It gives him a significant opportunity to clear his record and to turn his life around. And it also leaves on the table significant consequences if he fails to comply. I believe the author of the PSI noted that he has had some issues complying in the past, or that the agent has concerns about compliance in the past. I feel like, given his young age and given the seriousness of the offense, he should be given an opportunity to demonstrate that he can correct this issue and turn his life around. And if he can't, then the court has many options available to it to take more serious corrective measures. So I would ask the court to adopt the agreement of the parties, sentence him to 7411 on the drug file, sentence him to Haida on the other file. Thank you, Your Honor.
Thank you, Mr. Seeger.
Your Honor, and likewise, I would ask the court to do a similar like thing to give him the benefit of our sentencing agreement of 7411 and Haida. He is a young person. Clearly, he has exercised some poor judgment, especially in the jail, Your Honor. I think he was frustrated. He wasn't thinking clearly. He clearly made a bad choice on that date. I guess everyone can have a bad moment, but clearly that was not a good moment to make that choice. But be that as it may, Your Honor, he has expressed remorse. He has expressed a want to change. He does have some family support. He does have the ability to work. He is a young person who can change. And unfortunately, for a lot of people who are given this opportunity, they don't always execute it. So I'm hopeful that the court will give him the opportunity to have a special conditions of probation under 7411 and Haida. And to the extent that he can successfully complete it, he won't face the consequences of having a felony per se on his record, which really should be an enhancement to him to want to successfully complete his probation. So wherein if he previously struggled while he was on probation, there's all the reason to successfully complete this probation, which he indicated that he would.
Thank you. Anything you wanted to say, Mr. Waganshoots?
No, not really.
All right, I read through the pre-sentence report, so I'm familiar with what happened in this case. I'm familiar with your background and circumstances as well. And I don't disagree with counsel. So the court is going to fashion a sentence here that is heavy on the rehabilitation side and light on the punishment side up front. But there's going to be significant consequences to you on that punishment front if you don't comply with your probation in this case. You're going to need to find something more productive to do with your time than making drugs in your grandmother's basement. That is not a gainful means of employment that's going to sustain you as you get older. So I highly encourage you to find some employment that's productive, that's going to earn you an income, and that isn't going to involve felony charges.
Yes, Your Honor.
The court is going to place you on probation for a period of 12 months pursuant to the statutes we've mentioned with regard to the drug charge, 12 months probation pursuant to 7411. The court is going to adopt as the conditions of your probation all the terms and conditions listed in the report. The court is going to impose 9 months in the Kalkaska County Jail. You have credit for 0 days served, or I'm sorry, on that charge, you have credit for 6 days served. The court is going to hold that time in abeyance. So if you comply with your probation, you won't have to serve that time. If you don't comply with your probation, you'll have to serve that time immediately up front, and that's in addition to any penalties that you might face for violating your probation.
Yes, Your Honor.
So there's a significant consequence in terms of jail time here. And with regard to the count 1, malicious destruction of property, again, 12 months, that one pursuant to HIDA, the court's going to adopt all the same terms and conditions. As to that charge, also 9 months. We get credit for 2 days served, that time to be held in advance. As to each charge, the court is required to impose a crime victim's assessment of $130 and a state cost of $68. File 4842 only, the court is going to impose court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a supervision fee of $30 per month for your time on probation. Because both of these sentences are pursuant to HIDA and 7411, there are no appellate rights at this time. Mr. Ziegler, anything else that we need to address today? Mr. Seeger.
No, sir.
Ms. Wagner, did you want Mr. Waganshoots to check in with you at the probation office before he leaves?
Yes, please. Thank you.
Okay, so Mr. Waganshoots, you need to go across the way here following sentencing and talk to Ms. Wagner. That's all for today. Good luck to you going forward.
Thank you, sir.
Question. Hearing on this, it was stated that the charge 1 wasn't included in the bind on 4842. I haven't made
Technically, it's counts. It would be count 6.
right, and but at some point in that discussion, it came up that charge 1 on the information wasn't included in the bind. Sorry. Yeah, I can ask afterwards. Okay. I know I was because I took everything out to adjust to that, and now it's so I just want to make sure it was done correct.
All right, we're going to take a short recess. The court will be back in the record for the next hearing. we're on the record now in People versus Bell, case number 204415. If I can have counsel put your appearances on.
Ryan Ziegler, on behalf of people, Your Honor.
Your Honor, Chris Cook appearing on behalf of defendant Blake Bell.
Thank you. And the record should reflect Mr. Bell is present here in the courtroom today. This is the date and time set for sentencing in this matter. The court did receive Mr. Ziegler a written statement, victim's impact statement, which I did have a chance to review prior to the hearing today. Also a misdemeanor PSI. Mr. Cook, are there any additions, deletions, or corrections that need to be made to that?
No, Your Honor, thank you.
Mr. Ziegler, are there any from the people?
No, Your Honor.
And Mr. Ziegler, does the victim wish to address the court here today?
Your Honor, the victim is present in the courtroom. She does not wish to address.
Okay. All right, thank you. Anything on behalf of the people for elocution then?
Your Honor, it seems like I should have a lot to say about this case. Obviously, the defense and I have some significant disagreements about what actually happened in this case. I could talk for a long time about the facts and circumstances surrounding this case, but the court's already fully aware of them, having presided over that 4-day jury trial. I could talk a lot about what I think the appropriate sentence should be in this case, Your Honor, but there's a sentencing agreement in place for 11 months. Based on my conversations with the victim and negotiations with the defense, I continue to believe that that is an appropriate resolution in this matter. And so the court is already aware of everything that I would say. I really do not have a significant amount to add. There was some discussions about work release as part of the agreement in this case. I agreed not to take a position on work release. If the jail determines that he's eligible and appropriate for work release, the people will not object or get in the way of work release. If the jail determines he's not eligible or not appropriate, then so be it. So long as the court is comfortable proceeding along with the sentencing agreement for 11 months jail, the court's aware of all the facts and circumstances, I would ask that the court adopt that sentencing agreement and sentence the defendant to 11 months. Thank you.
Thank you, Mr. Cook.
Good morning, Your Honor. Thank you. Yes, the court has heard the facts of the case through the 4-day trial, and I will not belabor any of those facts before the court, but I would add that this was a compromise resolution and that my client has been now found guilty of stalking, a 1-year misdemeanor by the court through a plea of no contest. We have made arrangements with the Wexford County Jail. We've had a discussion with the court and with Mr. Ziegler. My client has to maintain a job. He's got 2 children he's paying child support for. He's got a business he is supporting, and he needs to work. Now, there's not any traditional work release through Kalkaska County, and since my client's going to be housed at Wexford County Jail, I did speak with Sheriff Taylor and Jail Administrator McDaniel, and they are prepared to house Mr. Bell beginning on Thursday evenings at 7 p.m. through the weekend, with a release on Monday morning at 6 a.m. so he can maintain a 4-hour workday with his employer, and that would allow him to pay his bills. I'm asking if the court does follow the recommendation, or at least the sentencing agreement of 11 months incarceration, that the court also indicate that there'd be no objection by the court to that kind of schedule for Mr. Bell under these circumstances. Thank you.
Thank you. Mr. Bell, anything you wanted to say?
I do, Your Honor. Morning. I'd just like to apologize for any inconvenience caused to John, Mr. Ziegler, yourself. This has been a 5-year disaster in my life. I have 2 beautiful kids. I have a great business. I don't feel that I need to be taken off and incarcerated, sir. I'm asking to be forgiven for anything. It's been really hard on me for 5 years. And to make this go on any longer, it just doesn't seem right to me. But I'm not the judge here. You are, sir. Taking my kids away from me is going to be the hardest thing in my life. I have my mother's retirement money I've used up. My dad's house is in hock because of me. I need to pay these things back, and I need to continue building this life that I have that is great. This poor inconvenience that it's caused, it's just so upsetting to me. And I've had enough of it, and I want this to be out of my life and away. And I just want to continue doing good, doing what I do. I have a great business. I enjoy it, and I love it. And that's all I have to say. And Don't take me away from my children, please. Thank you.
All right, obviously, I presided over the trial. We had a fair amount of pretrial practice in this case, so I was aware of the allegations prior to and kind of the defense's position. Certainly had an opportunity over several days to hear all the testimony from witnesses from both sides in this case, so the court is very well versed. I think as both counsel have indicated in terms of the allegations here. Couple things I would say, I mean, you know, nobody was there that night except you and Miss Scobie. And, you know, unfortunately, Miss Scobie's memory is unclear from her side of what happened. I don't know if yours is a whole lot clearer. So I don't know that anybody's really going to know exactly what took place between the two of you. I will say this, that it was my impression after listening to the various statements that you made, that there certainly was more going on than I think what certainly what you've admitted to and what you were willing to admit to the police during those various interviews. There's no question in my mind that I can acknowledge that you gave false statements to the police. I don't think you were entirely truthful on the stand during the trial about what happened because your story was different yet again. And so when I have somebody telling multiple different stories at different times, that indicates to me that the truth is somewhere in there, but they're not willing to admit fully what happened. And whether you ever do or not to anybody else, I think you need to admit to yourself that there's more that went on because there was a motivation for the various stories somewhere in there. I also think that, you know, a jury not being able to find you guilty beyond a reasonable doubt is one thing. What really happened is something completely different. And while the jury wasn't able to come to a unanimous verdict, the fact that they spent so much time deliberating indicates to me that this was not a clear case of he didn't do it. And I think, you know, in some ways, your decision and Mr. Cook's counsel was dead on in terms of getting a resolution of this, because had you been found guilty, I mean, you would have been taken into custody and that would have been it. Boom, right then and there. And you want to talk about not being able to earn money and not being able to see your kids. That would have been it for you for a really long time. So I think you received some really good counsel in terms of this agreement here. I think that given the difficulties throughout the trial and in the jury reaching a verdict, I think the agreement is also reasonable on the part of the prosecution. I think for both sides, given the difficulties in this case from a legal standpoint, that doesn't help the victim in this case. But unfortunately, legal realities are what they are. So all in all, I think it is a reasonable resolution. I think that the sentence of 11 months is also reasonable. I think it accounts for your wrongful conduct in trying to cover up what happened by your various statements. And what I view again is a lack of truthfulness, including even your testimony on the stand. So I think it's a reasonable resolution, and I think it's also reasonable given the circumstances for the prosecution to not object to work release, and I'm not going to object to that either. I've had in chambers discussions with Mr. Cook and Mr. Ziegler about that, and in many ways, I think that adds a level of punishment for you because it's going to drag us out longer, and you know, you're either going to be working or you're going to be in jail, and I think those are significant consequences for you to pay. So the court finds that the sentence and the recommendation is appropriate. The court is going to sentence you to 11 months in the Kalkaska County Jail. You do have credit for 3 days served. The court does not have any objection to participating in work release, as Mr. Cook has outlined here today on the record. crime victims assessment of $130, court costs of $325, and a state cost of $53. You do have the ability to seek an appeal of the sentence. Because this is a misdemeanor charge, there's no written appellate rights, but if you wanted to request an appeal, Mr. Valley would have to file that paperwork within the next 21 days. If you had more questions about how to do that and whether or not to do that, Mr. Cook, I'm sure would be happy to help you with that process. Mr. Sigler, is there anything further we need to address for the record? Mr. Cook.
Nothing, Your Honor. Thank you very much.
Mr. Bell, you are remanded to the custody of the county at this time. Court's going to take a brief recess. We'll be back on the record at about 10:05. Okay, we're on the record in People versus Truce, case number 234848. Also put your appearances on.
Brian Ziegler, yeah, the people are.
Thomas Sigler appearing with and on behalf of Mr. Truce. Your Honor, I think there was maybe somewhat of a small error that was made relative to whether or not Mr. Truce was in our custody or in the custody of another county, which he's still in Wexford County. However, he's under sentence in Wexford County. So I think it may have been a small oversight wherein either a writ was required or some other mechanism to secure his appearance. But I do know he's there because I went out and visited him, and he's not here for that reason. But I think the sergeant was trying to work it out where he could maybe appear by Zoom. I know that the client wanted to close his sentencing to the extent that that was possible. But that's all I can really say here.
I did speak with the jail sergeant down there. All their Zoom machines were tied up, but he said the minute one frees up, he's gonna call me and they'll put him on. So, and that is what happened. There was a mix up. It wasn't understood that he's actually in their custody, so he's not on our jail list.
Gotcha.
So the person that put together our transport list didn't know he was in custody and we didn't have a writ, so.
Because he's under their.
Because he's in their jurisdiction, even though he is in Wexford.
Makes sense.
So that's where the lines got crossed.
Okay. Right, I do have a device signing in here, so let's just see who this is.
Your Honor, while you're kind of maneuvering, I did talk to Miss Miller, and Miss Miller would ask the court to consider recalling her case, at which point I think we can resolve it.
Okay. Are you in text communication with her?
I did. I asked her to please log in.
Okay.
I think that's Mr. Hiddle. Mr. Hiddle.
Recognize him.
I believe that's Mr. Hiddle. It's
Yes, sir.
hard to tell, but it appears
That
that
is.
is.
Okay. I'll recall him.
Let me go get Mr. Truck.
Go back off the record then. Until we get.
Sorry about that.
It's all right. So it goes. Okay, Miss Miller, are you able to hear me?
Yes, sir.
Okay, we'll go back on the record and people versus Alexis Miller. And Mr. Seeger, you had further communications with Ms. Miller yesterday.
Yes, Your Honor. Your Honor, it's my understanding that Ms. Miller would consider a plea to an edit count 2 of possession of analogs, which is a 2-year felony. In exchange, count 1 and the habitual offender fourth notice would be dismissed. Additionally, Your Honor, the people have agreed to a sentencing cap of a county time sentencing cap, which.
All right, Mr. Ziegler, is that a correct statement of the plea offer in this case?
It is, Your Honor.
And Mr. Seeger, are we taking the factual basis to the methamphetamine?
Yes, Your Honor.
Ms. Miller, were you able to hear all of that?
Yes, sir.
Okay, and I know this morning you indicated that you wanted to go forward with trial. It sounds like this might be a little bit different of an agreement. Have you reconsidered that?
Yes, sir.
Did you want to enter into that plea agreement here today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Miller, are you currently on any kind of probation or parole?
No, sir.
And you understand that the maximum possible penalty that you could face for possession of analogs is up to 2 years?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
So the date that I have, this happened a while ago, it looks like, back on January 15th of 2021. Is that the correct date to the best of your recollection?
Yes, sir.
On that date, were you present here in Kalkaska County?
Yes, sir.
On that date, while you were here in Kalkaska County, did you have possession of some methamphetamine?
No, sir. I had possession of the used syringe.
Sorry, that was muffled. Can you repeat that?
I had possession, or it was found in my coat, a used syringe.
So there was a used syringe in your coat?
Right, but my coat wasn't on me when they arrested me.
Okay, where was your coat at?
Inside in the house or whatever. Like I come out the house and the people whose house it was or the cop said that he wanted my coat or whatever, that he had to have it for whatever reason, and they went back in and got it for him and brought him out the coat that they have where they found the syringe in.
Okay, did that syringe have some methamphetamine residue on it?
I'm not sure. The tests say yes, so
Okay, it tested positive for methamphetamine?
yes.
Do you have any reason to doubt the accuracy of that test?
I'm not sure to answer that, so no, I guess not.
Okay. And are you saying that somebody else put that in your coat pocket?
A possibility, but I'm not sure. I just want this over with. So
Oh, well, was it yours? I mean, did you put it in your coat pocket or did somebody else do it without your knowledge?
to my recollection, I can't per se that I put it in my coat pocket. Just things being as they were then, I highly doubt it, but I don't know. I was unwanted where I was at that time, and the homeowners who I was dating their son, they called the cops because I had a child support warrant at the time.
Your Honor, may I assist with the factual basis?
Sure.
So, Ms. Miller, on or about 1/15 of 2021, you were in Kalkaska County, correct?
Yes,
All right. And at some point in time, you came into contact with law enforcement, correct?
yes,
And at some point in time, they found in a jacket that belonged to you, methamphetamine, correct?
no, they found a used syringe.
All right, and that used
There's
syringe
no
had.
drugs found.
Yes, Ms. Miller. All right, Ms. Miller, I don't care if you have a trial or not, and I've explained this to you enough times. So you're either taking a plea or you're not. It's your choice. It's not mine. I'm not going to force you to do anything. The syringe was either yours or it wasn't. And you can either have a trial or you can accept a plea. But the court has already been gracious and given us another opportunity. So the syringe was either
accepting
yours,
it.
wasn't.
I'm just
So I
not
don't
gonna
care what-
lie and bend what
All
actually
right, then
happened.
let's
to
have
fit
a,
what
then
you
let's have a
said.
trial then. Let's have a trial
I
then.
told I'm
Ms.
taking
Miller.
it. I'm just not gonna lie, but to get up to that point to be able to take this plea, I'm not gonna. That's seems asinine.
Okay, well, but you can't establish a factual basis, Ms. Miller, if you can't establish that it was yours. If it wasn't yours, well, then it wasn't yours. If it was yours, well, then it was yours. We can't have our cake and eat it too. Did you put it in your jacket at any point in time, or are you disputing, or I think you said that you don't recall, it could have been yours, it may not have been yours? Is that your statement?
Right, I don't recall.
All right, so, but
So I'm
during
just-
that
yeah,
time
I'm
period, had you been using drugs during that time period? Is it likely that the syringe with the residue was yours?
It was found in my possession, so therefore it would be mine.
Okay, so the syringe that was found in your possession was in fact yours, is that correct?
Sure.
Okay, no further questions.
Mr. Ziegler?
Your Honor, I think the testimony is established that the coat was hers, she was under arrest, she had control of that syringe. She seems to say she has a lack of memory about whether she put it there, or whether someone else put it there. But she's established that it was in her possession and control. It was a coat that belonged to her. I think there's a sufficient factual basis to establish that there's possession, at least constructive possession. So I would ask the court to accept the plea.
All right. I mean, I have to agree with Mr. Seeger here. I mean, the statute requires that she knowingly or intentionally possess the syringe. So Miss Miller, here's the thing, and Mr. Seeger's tried to explain this as well. I can't find you guilty of this charge unless you knowingly or intentionally possess that syringe. Do you understand that?
Right. I
So,
guess I don't know,
Mr.
I'm
Seeger,
taking fault for
listen
it.
to me. Listen to me for a second. Mr. Seeger is correct. So you either knew that syringe was in your pocket or you put it there, or you had no idea and it was just found there. So which of those options is the truth in this case?
I have no idea if it was mine or if anybody else put it there. I
All
can't.
right, well, I'm not gonna accept your, I'm not
If
gonna
there is, there
accept,
isn't. I'm gonna.
I'm not gonna
because I just
accept,
don't remember. At that time, I had a drug problem. I can't say that I did or didn't do it, but will say yeah. I was just around other people at that time that also did those things. So, I don't know. But I was in the wrong for being around those people.
okay, so you can't be convicted of a crime for being around the wrong people. So if you didn't know that it was there or you didn't put it there, I can't find you guilty. And the only other option we have is to go to trial. So I'm gonna give you one more opportunity. Did you know it was there or did you put it there?
No,
Very
I didn't
simple
know it was
question,
there. No,
and
I
it
didn't- I
only
didn't put it
requires a
there
yes or no answer.
unintentionally, But yeah, I'm claiming it is mine because it was my coat.
Okay, again, I'm gonna ask you one more time, and it's a very simple yes or no question. Did you know it was there or did you put it there? Yes or no?
Yes.
All right, thank you. The court finds now there is an adequate factual basis. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Ziegler, or I'm sorry, Mr. Seeger.
Yes, sir.
Ms. Miller, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You're going to be contacted by somebody from probation regarding a pre-sentence report. It's important that you follow through with that contact so that we can have that completed. The sentencing hearing will be in person, so once you receive the notice of date and time of that hearing, you will need to be here in the courtroom in Kalkaska County. I'd also recommend that you stay in touch with Mr. Seeger, your attorney, prior to that hearing. That's all for today, and you're free to disconnect at this time.
Your Honor, can we get her
Yes.
phone number, please?
She's already gone, but Mr. Seeger has that.
Okay,
Forward, Ms. Wagner.
thanks.
Mr. Travis, are you ready on Mr. Fuller?
Yes, Your Honor. Mr. Fuller is present in the courtroom.
Oh. Court calls People versus Fuller, case number 234852. Record should reflect Mr. Fuller's present here in the courtroom. Fuller, you can just have a seat right there if you want.
Thank you.
All right, Mr. Travis, how do you want to proceed?
Your Honor, we are actively discussing plea discussions in Mr. Fuller's case, and we're somewhat close, but there are some other matters that I believe Mr. Ziegler wants to look into before he ultimately decides what specifically the offer is going to be. There's a misdemeanor matter attached to this file. I think he wants to try and talk to some folks before he decides what the ultimate offer is. There is a strong chance that we will have a plea offer, but we'd like some more time to continue the discussions.
All right, thank you. Mr. Ziegler?
People have no objection. Your Honor.
How much time do you think we need to get those issues hammered out?
No, I expect to be within the next 30 days.
Okay, is that adequate for you as well, Mr. Travis?
I believe so, because I think we kind of know everything that's out there at the moment.
Okay, so we'll set this for a status conference and plea hearing in 30 days. Mr. Fuller, did you have any questions about that at all?
No, sir.
Okay, all right, thank you. That's all for today.
Thank you, Your Honor.
That's it. Oh, I did it. Thank you, though. See you, Terry.
And I do want to address Mr. Hill's case real quick. That is case number 234-859. Council can put your appearances on the record.
Ryan Ziegler on behalf of Plea.
Kyle Travis on behalf of Mr. Hiddle.
So the court received notification from Mr. Hiddle and he did attempt to appear by Zoom. But the court received some communication that he's ill and may have COVID. Is that what you received as well, Mr. President?
Yes, briefly. We had a very short conversation with them just a couple minutes ago, and that was my.
So it's the court's practice not to allow last minute appearances by Zoom. So the court's going to set this for a show cause for the next full motion day. And if you could just notify Mr. Hiddle that he needs to bring some kind of, proof of-
Documentation or something.
Yeah, some kind of documentation from, a medical professional, not just something in writing for himself, or, you know what I mean?
Yes.
Something verifiable, let's put it
Okay.
that way, to the next hearing, and the court will simply reset this.
Okay, thank you, Your Honor. And it was our intention. We had, I've been in discussions with Mr. Ziegler. We were going to ask for an adjournment to look at some more discovery.
Okay.
So,
All right, we're ready with Ms. Solis case.
Ms. Solis is in the courtroom, and we are ready, Your Honor. I did have 3 letters that I have shown to Mr. Ziegler that are from Mrs. Solis.
Okay. I'll take a look at those real quick here. Did you want these attached to the PSI?
Yes, Your Honor. Please.
All right, I've had a chance to review those. I also had a chance to review the pre-sentence report prior to the hearing today. Ms. Solis, did you have a chance to go through that report and talk to Mr. Travis about that?
I did.
Okay. Mr. Travis, are there any additions, deletions, or corrections?
I guess maybe a mild clarification. On page 3, under the description of offense narrative. And I think if rereading it like the 3rd time, it does say what we wanted to say, but basically 4 lines down, she stated her and Andrea have been together for 5 years and that she resided in the home for 3 years. Ms. Solis just wanted to make sure it was clear that she did not live with Jennifer in that home for 3 years. And it kind of could be read as though that was what was said. I think on reading it again, this is from Jennifer's perspective. So it is saying that she had resided in the home for 3 years. But when we read it the first time, it was a little bit confusing and she wanted to clarify that she had not lived in that home for 3 years.
Okay. All right. Any other changes that need to be made?
I don't believe so, Your Honor.
Any challenges to the guidelines as scored?
None, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the guidelines as scored?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, the agreement in this case was for 7411 to possession of narcotics. I still believe that that is an appropriate resolution given the facts and circumstances. The allegations are essentially that they were using crack cocaine, and in doing so, they were cooking that product. So that was the basis for the charge of delivery, manufacture, possessed with intent to deliver, was the changing of cocaine to crack cocaine. But there's no allegations that they were actually doing deliveries. Essentially, they were just using that substance, cooking that substance in residence. Officers went there for a warrant, happened to observe it through a window. The defendant has no felony history and only 3 prior misdemeanors. I certainly understand the PSI author's concerns about her doing poorly on probation the past couple times. But given that this is her first felony offense, combined with the fact that she's going through treatment, combined with the letters that the court has in its possession, I still feel it's appropriate to give her the benefit of 7411 and to give her an opportunity. So the people would ask that the court go along with the sentencing agreement to 7411 and sentence her in accordance with that statute. Thank you.
Thank you, Mr. Travis.
In your honor, to further fill in, and I appreciate that from Mr. Ziegler, the way this happened is Mrs. Solis was on probation when this charge came about. So then she never got out of jail. Initially, when I interacted with her, she was in the Kalkaska County, or the Wexford County Jail, but she was in custody. So the whole time we were in front of Judge Boudet, and usually Judge Boudet is quite diligent about testing, making sure people are testing. She was in custody. So there was never kind of the typical, hey, you're testing, you're not testing situation. She actually was approved by Judge Boudet as part of her probation violation sentence that she could go to rehab. So she went to rehab, then had gotten out actually just like a week or so before on our first court day where she pled. So Mrs. Solis was not testing when this came up. She, I think, pretty told probation, no, I'm not testing. And she honestly didn't realize she was supposed to. And that sometimes as well, it's hard to believe. I know Judge Boudet is on top of these, but that situation never occurred because she was in custody the whole time. Then she was in rehab. So she did start testing. I think she's got 1 test under her belt as we went through this report and said, hey, you're not testing, and we were supposed to be. So I guess I just point that out because it's not you've been told many times to test situation and you're still refusing to test. It was an error on her part, and she acknowledges it was her error, but it doesn't appear to have been an intentional or a refusal to test or a I'm still using type situation. It does appear to have just been the circumstances of her coming into the circuit court and being discharged from probation with a successful rehab term, which actually enabled her to do about, I think, 40 days less in jail than Judge Boudet would have otherwise authorized. So I understand, again, we're coming here from a failed probation, but from that failed probation, she's moving forward quite well, and it's clean, and as the honor can see. So I just wanted to explain that a little bit and ask the court to follow or grant her 7411 status because she is very motivated to move forward and stay clean.
All right, Ms. Solis, anything that you wanted to say today?
I think we did it pretty well. I can't change my past choices or my actions. I was in my addiction at the time that I was messing up probation and messing up my reputation with the court. Rehab has done amazing for me. It's life-changing. So I just, I'm happy I have my family back. I love my kids. I'm spending every single minute with them. I hope to never go down this path. I can't say I won't because there's always a possibility. You get what I'm saying? Okay. But I'm trying, and I love my life now, and I have a whole different outlook, a whole different meaning. I have my self-esteem back, and I'm happy for once. I also cry a lot, which is new to me, sorry. But I'm trying every day, every second. I'm just trying.
Okay, I read through the report. I'm familiar with what happened in this circumstance. There's also a lot of information in there about your background and circumstances as well. And then, of course, I read those letters that were submitted on your behalf. And, you know, this is very serious conduct that you were engaged in here. And it's the kind of thing that the court has a real interest in deterring, stopping from happening again and punishing. But I also think that there's, you know, a goal to be achieved through rehabilitation. And it appears that you're taking that part of it seriously at this time. There's really no downside to the court or the community in giving you an opportunity to continue on that path with a fairly significant punishment held in abeyance as a consequence if you don't.
Yeah.
Because you're either going to comply with probation, you're going to continue on the path of recovery and move past this, or you're not. And if you're not, then that's when the punishment deterrence phase for me, in my view, kicks in. So the court is going to give you an opportunity through probation under 7411. The court is going to adopt all the standard terms and conditions of probation. The most important of which is going to be that you not use or possess any controlled substances or be with anyone who is using or possessing those substances. So that means you got to stay away from the people who are involved in it.
No, I agree.
Because that's going to get you just as much trouble as if you have it yourself. Also that you participate in and complete any inpatient or outpatient treatment programs that are recommended to you by your probation agent, as well as all the other standard terms and conditions of probation. The guidelines in this case call for a sentence of up to 9 months. Given your conduct, I think that warrants it, and the court is going to impose that but hold it in abeyance. So if you comply with your probation, then you wouldn't have to serve that time. But if you don't, then that time is going to kick in immediately. You know, no stops, boom, right to jail. And that's in addition to any penalties that you could face for actually violating your probation. So there's a very significant consequence to you not complying. So the court is going to place you on probation for a period of 18 months. Again, standard terms and conditions pursuant to 7411. The court is going to impose 9 months in the Kalkaska County Jail with credit for 20 days served. The remainder to be held in abeyance to be served at the discretion of the court. The crime victim's assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, a $68 state cost, and a supervision fee while you're on probation of $30 per month. Because this sentence is pursuant to 7411, there are no appellate rights at this time. Ms. Wagner, I know you authored the PSI. Are you going to be the supervising agent in this case?
Yes, Your Honor. She can just come on over after court, please.
Okay, so Ms. Solis, you need to go across the way to the probation office and meet with Ms. Wagner once you're done with work here today. Mr. Ziegler, anything further for the record today?
No, you are.
Mr. Travis. Thank you. Good luck to go.
Thank you so much.
Mr. Travis, I think we have Mr. Truce and
Hey, Your Honor.
oh, that's you, Mr. Ziegler. Mr. Truce, are you able to hear me okay?
Yes, sir.
We're on the record in People versus Truce. This is case number 234848. The record should reflect Mr. Truce is present today by video from Wexford County Jail. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Thomas Seeger appearing with and on behalf of Mr. Truce.
All right, this is the date and time set for sentencing. Mr. Truce, you do have the right to be transported here to the courtroom in Kalkaska County for sentencing. That's not something we would be able to do today, but if you wanted to exercise that right, I would sign an order to have you transported here. You can waive that right and we can go forward with sentencing today by video. Do you know how you'd like to proceed?
Just proceed for sentencing, sir.
Okay. Have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, sir.
All right, Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, sir.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, the defendant pled guilty to one count of fleeing and eluding fourth degree. Some other counts were dismissed. The report does a good job of laying out what happened, but essentially this was a pursuit that came into our county from Wexford County. So he was fleeing from officers in that county, continued to flee from officers in this county. Once he got out of the vehicle, he ran from officers. He failed to follow the commands of officers. So this was a circumstance that put the officers in danger, both on the road and after the vehicle chase had halted, where he continued to resist their commands. So I do have a lot of concerns about his conduct in this case. This is not his first felony conviction. It's not his first conviction of any kind. The guidelines are 0 to 11. I don't see any reason why a sentence in the middle of those guidelines would not be appropriate. I do agree with the recommendation that the defendant be sentenced to jail. He's had some previous attempts at probation that were not successful. He has other pending criminal matters. So I would ask the court to sentence him to a jail term somewhere in the guidelines.
Thank you, Mr. Seeger.
Your Honor, I would just ask the court to impose court costs and fines. He is currently serving a sentence to which my understanding is that he was sentenced to 300 days. And my only per se concern, Your Honor, in as much as he is being housed by Wexford County, and to a certain extent he's housed for the benefit of Kalkaska County, I wouldn't want us to absorb their housing fees. So if the court gave him a sentence somewhere in the middle of the guidelines, that probably would not affect ultimately what happened with the housing fees. We wouldn't have to absorb any costs relative to it. The sentencing guidelines are not greater than that which he's already been sentenced to. He does have some other pending matters. I did speak to his attorney in Wexford County. To what end is that's going to result in, I can't specifically say. The one thing that I can say to his credit is he is a young person. He was remorseful. He never really expressed that he didn't have any responsibility for his actions, and clearly he made a poor choice on that day. But be that as it may, Your Honor, if the court would give him a sentence that is somewhere in the middle of the guidelines, that might be appropriate. And also it would solve a practical problem in as much as he's theoretically, because everything will work concurrent to each other. The county would not absorb any additional costs.
All right, thank you. Mr. Truce, was there anything that you wanted to say today?
Oh, Your Honor.
All right, I had a chance to review the report. As Mr. Ziegler indicated, I think it does a good job of laying out the circumstances that bring you before the court here today. There's also a lot of information in that report about your background as well. The court has some serious concerns about your behavior. It looks like you were on drugs and driving a car at a high rate of speed and really driving it until it just wouldn't go anymore. And then, as Mr. Ziegler indicated, then you got out and ran from the police. All of that, and across 2 different counties. During that, you're obviously put not only yourself, but everybody else who was on the road at that time in danger of being injured or killed, as well as the police officers who were involved in that. I think the court has an interest in discouraging and punishing that type of conduct. And so I think a sentence at the top end of the guidelines is more appropriate in this case for those reasons. So the court is going to sentence you to 10 months in the Kalkaska County Jail. You do have credit for 40 days served. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a state cost of $68. The court is going to provide you with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal if you wanted to seek an appeal. Mr. Ziegler, is there anything else that we need to address for the record today? Mr. Seeker?
No, sir.
All right, Mr. Truce, that's all for today. The court will send that paperwork to you at Wexford County, and the court is going to disconnect at this time.
Thank you.
Thank you. Mr. Travis, are you ready on Mr. Armstrong's case?
Yes, sir.
All right, this is People versus Armstrong. This is case number 234838. Should reflect Mr. Armstrong present here in the courtroom today, but you have counsel for your appearances.
Kyle Travis, on behalf of Mr. Armstrong.
All right, Mr. Armstrong, you had a chance to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, ma'am.
All right, Mr. Travis, are there any additions, deletions, or corrections to that report?
Your Honor, I don't know if there are really additions or corrections, but there are some things I wanted to point out relative to his criminal history, which I think is a large effect on probation's recommendation. I've spoken with Mr. Ziegler about this. These two Battle Creek felony cases that are mentioned. The one, and I had a chance to speak with Mr. Armstrong's attorney down in Battle Creek about this. She actually contacted me when she found out about this case, because it was her belief from the Attorney General's office that this case wasn't being pursued. So the narrative of the similar action to this case down there, the matter down there is based off of a criminal enterprise theory. There are multiple parties charged down there. And what she informed me is basically the two allegations that related to Battle Creek, related to Mr. Armstrong, were allegations that occurred when he was a juvenile. And the reason they were charging him as an adult was they were tying this Kalkaska case to make their criminal enterprise and make it an adult case. And she had been informed by the AG that this case wasn't being pursued. Mr. Ziegler can comment on that, but I don't think the AG has communicated with anyone in Kalkaska about this, but they were telling counsel down there that this was going that way. So she was very concerned when she found out about this, and they're going to pursue their remedies down there. But interestingly, Mr. Armstrong in Battle Creek by the AG was one of the few, if only, people being proposed a HIDA solution because of his age in that larger scheme. So even though it looks pretty bad that he's got these two types of cases, we were somewhat aware there were other cases, but the linchpin of the adult case in Battle Creek is based off of the conduct here in Kalkaska, is what his attorney is informing me. And she was quite bothered because she was being, she called me quite frantic when she found out this case was going on, because she was of the belief it wasn't. And she's like, I've read all your reports, I have all the discovery, I know everything about that case, because it is how the AG is making this case on him as an adult. The other issue, which I think was quite concerning to probation, is this allegation of assault with intent to murder and a weapons felony firearm. I spoke with her about that. She had no idea about that. And when she looked it up, she said, no, we were never appointed. I don't think he was ever arraigned. It is indicated that was dismissed fairly quickly. So I don't have a lot of information other than that a case appears to be going nowhere. Somewhat very speculatively, the attorney indicated it may have something to do with Mr. Armstrong's brother. He is facing more serious charges down there in Battle Creek, but it does, by all accounts, appear as though Mr. Armstrong is not being pursued, investigated, and that is not going anywhere, which I think this is important because I think it has a lot to do with probation not suggesting that HIDA would be appropriate. So those two factors not being on the table, I think changed this a lot. So I just want to point that out, and I've talked with counsel in Battle Creek, and they're saying not even an arraignment, no indication that that other case was on the law enforcement side, gone before it ever even got to a defense attorney. And just that the similar conduct that he's charged with down there in Battle Creek is largely this conduct that he's here in front of your honor is what makes it an adult case. So I just will allocute later, but those are what's reported is not factually inaccurate, but there's a lot more to it than what it looks like on its face.
Okay, all right. I certainly will take that information into account in terms of determining the appropriate sentence. So thank you for that clarification. Are there any other corrections that need to be made?
Not that I'm aware of.
Are there any challenges to the scoring of the guidelines?
No, Your
All right. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, so, Your Honor.
Okay. Anything on behalf of the people who are out?
Your Honor, this is a circumstance. There were 4 gentlemen involved, and they decided to try to break into a local business, the Green Farm store downtown. They were on camera using crowbars to try and force the door. When the cops arrived, they ran from the police, had to be chased down by law enforcement. In Mr. Armstrong's case, he's a very young man, he's 18. This will be his first felony conviction, although the court's well aware of there's other matters pending. I think I might sound like a broken record today, Your Honor, because I continue to believe that HIDA or deferral is appropriate for this defendant. Doesn't have any prior felony history. He only has a few juvenile misdemeanors on his record. Given his age, I continue to believe that rehabilitation is an important part of the court's function and of sentencing younger people, giving them an opportunity to demonstrate that they can turn their lives around and comply with the law. So I continue to believe, despite the seriousness of the offense, and perhaps in part because of the things that Mr. Travis was saying, that he continues to be a good candidate for HIDA status. So I would ask the court to follow the recommendation insofar as recommends placing him on probation and to give him an opportunity under the Home's Youth Training. Thank you.
Mr. Travis.
Thank you, Your Honor. Your Honor, relative to the sentence and to HIDA and to Mr. Armstrong, obviously the behavior here was not good. Mr. Armstrong has family support. His mother is here. She's been here with him for many of these court hearings. His father's attended some of them. They're very motivated to help Mr. Armstrong succeed in life. His mother was just telling me she's basically got him hired in where she works. They're just waiting to see what happens here, obviously, before that. So he's going to have employment hopefully very soon. And he wants to, him and I have talked. He wants to move forward. I think he and these other young gentlemen, I think one of which has already been in front of Judge Hunter, got wrapped up into what we kind of suspected was some older individuals directing them what to do. And from talking to the attorney in Battle Creek, that probably is what is going on. But these guys are the children, if we will. I mean, he's 18. And at one point he was a juvenile. The younger people, it seems like, even though there's been some errors and mix-ups in that, even the AG wanted to treat them a little differently than the seemingly more serious people. Mom is very motivated to keep Mr. Armstrong in a good environment. They've actually moved from Battle Creek to Kalamazoo to kind of get him not around these folks. I think there was some involvement with probably some pretty bad people. And it looks like Mr. Armstrong broken away from that. He's talking about the right things. He's talking about moving forward. He's talking about working. We've talked about the importance of, if he's given this opportunity on HIDA, that this is not something that he gets to just mess around with, and it's not a joke. He's got to be very serious. And he largely, I think, gets that and has been compliant in this case, going forward, and I think you will comply, and I think you will benefit if the court sees fit to grant him HIDA in a term of probation and monitoring, because he's on kind of on the edge. I think he got involved in some pretty serious stuff and some pretty bad people, but luckily he's got family support that's worked hard to pull him out of it, and he understands that he can make a choice. He can go forward and be a happy, successful member of society, get a regular job and live a good life, or he can go down the road where unfortunately, not that I spent a lot of time down there, but I did a little bit of time in the prosecutor's office in Detroit as an intern. I talked to some of these guys. We had a case where they were actually robbed by some other guys, and I got to interview and talk to them. Making it to 30, 35 in that lifestyle just doesn't happen. It's not a good route, and it doesn't go well, and you're looking at a short life. And I don't think Mr. Armstrong wants to do that. So I would ask the court to grant him HIDA and follow the recommendations. Thank you.
All right, Mr. Armstrong, anything that you wanted to say today?
Yes. Well, I first want to say that I take ownership and responsibility for my actions. I know better and I was raised better. I messed up. This has been a very eye-opening experience for me, and one that I would not like to repeat. I have plans for my future, and a felony conviction will make those much harder to achieve. I have already made changes. I moved with my mother out of Battle Creek, Michigan to Kalamazoo to start over. I have been in contact with a staffing agency that will let me start as soon as this is over with. I have been working, getting my high school diploma, and I'll start on November 10th for my orientation. I know what I did was wrong, and I want to get back on the right track with HIDA. And I know that if I screw up, it enters on my record and that it will be my fault, but I will make sure that I don't screw this up, Your Honor.
All right, thank you. I had a chance to review the report, so I'm familiar with your circumstances and background. I'm familiar with what happened in your conduct in this particular case, brings you before the court. So taking all of that into account, along with what both the lawyers have had to say, I think this is a circumstance where HIDA is appropriate. I think rehabilitation, particularly at your age and stage of life, is important to give you an opportunity when young people do get off on the wrong track, to give them a chance to get back on that right track. And there really isn't any downside to the community in giving you the opportunity for that. And then there's, in my view, some tremendous upside if you do get things on the right track and go forward. So I don't have a problem with HIDA, and I think it's appropriate to accomplish the goals of rehabilitation. I do think, though, that there needs to be an aspect of punishment here, particularly for somebody who's your age. You need to understand that there are consequences to your actions. And in this case, driving here from Battle Creek with other individuals, with ski masks and crowbars, and breaking into at least one business and then running from the police after that, is absolutely wrongful conduct. And it's conduct that as a society and community, we're not going to tolerate. And there needs to be a deterrent effect and a punishment for that as well. So I think a sentence that incorporates both of those things is appropriate and reasonable. So the court is going to place you on probation for a period of 12 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to make that probation pursuant to HIDA. The guidelines in this case are 0 to 9. The court finds that an appropriate sentence would be 3 months or 90 days in the Kalkaska County Jail. You do have credit for 1 day served. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, state cost of $68. The court is going to order that you pay $30 per month as a supervision fee during the time that you're on probation. Because the sentence is pursuant to HIDA, there are no written appellate rights. Mr. Ziegler, is there anything else that we need to address on this file today?
There you are.
Mr. Travis.
All right.
All right. Mr. Armstrong, you are remanded to the custody of the county at this time. Mr. Isles, ready with your client?
Little brother. You want to tell me about your little brother? All right. You gotta look. Come on. Love. Say bye. Thank you, young.
All right, we're on the record as People versus Weaver, case number 224718. Ms. Weaver's present in the courtroom. If I could have counsel put your appearance on.
Scott Isles on behalf of Ms. Weaver.
And Mr. Isles, how did we want to proceed on Ms. Weaver's case?
Your Honor, my understanding of discussions with the probation officer, we're going to be pleading to count 2 of the probation violation. She'll dismiss counts 1 and 2. There's discussions with her this morning just before court about getting the fines paid. My client just moved to Kalkaska, so she lives up here now and she's got some banking issues trying to get her money set together. So the probation officer said, go ahead with our agreement and she could get it paid in the next few days.
Okay, and then we would simply discharge Ms. Weaver from her probation?
Yes.
Okay.
Your Honor,
Mr. Yeah,
just to make it clear, what Mr. Isles is referencing is the supervision fees. Her court local fees are paid in full.
okay, thank you. Mr. Ziegler, any objection to proceeding that way?
No, Your Honor.
Okay, Ms. Weaver, have you had a chance to talk to Mr. Isles about this?
Yes, sir.
Is that how you'd like to go forward?
Yes.
All right, if you'd raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, thank you. Ms. Weaver, you understand that by pleading guilty to this probation violation, that it could subject you to the maximum possible penalty under statute, which is up to 4 years?
Yeah.
Okay, and aside from what we've discussed on the record today, has anybody promised you anything to get you to plead guilty?
No, sir.
What is your plea to that count 2 of the alleged violation?
Guilty. It was an altercation.
Okay, has anybody threatened you with anything to get you to plead guilty?
No, sir.
And are you pleading guilty because you did violate your probation?
Yes, sir.
On or about October 1st of 23, were you on probation here in Kalkaska County?
Yes, sir.
And were you aware that one of the conditions of your probation was that you were to not engage in any assaultive, abusive, threatening, or intimidating behavior?
Yes, sir.
And did you engage in that type of behavior on or about that day?
Yeah, forcibly I did.
Okay. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you did violate your probation as alleged at count 2. The court will accept the guilty plea. And again, the court will simply. Ms. Wagner, are there any other issues that we need to address in terms of sentencing, or is that it?
No, Your Honor, I'm just recommending that she be discharged without improvement. No further action to be taken place.
Okay, Mr. Isles, was there anything else that you wanted to state?
Your Honor, this was the final act in a chaotic relationship with her husband. She's moved up here. She's filing for divorce. And this was resolved down there with a disturbing the peace plea. So if this had been something where she had backslid with drugs, I would certainly understand the considerably different recommendation that we have, but I think this is appropriate given the circumstances.
All right, thank you. Ms. Weaver, was there anything else that you wanted to say?
No, Mr. Isles said it all.
Okay. All right, given the circumstances, the court isn't not going to impose any additional penalties. The court will simply preserve any outstanding fines and costs, discharge Ms. Weaver from probation. And That's all we have for today. Just make sure you stay in touch with Ms. Wagner.
I will. Thank you.
Thank you, Your Honor.
And Ms. Wagner, I'll sign that order that you provided previously.
Thank you. And if you can give it to Agent Barrup, I think he's in the courtroom, and I'll get it back to the clerk's office. Thank you.
Thank you.
Your Honor, may we approach about something completely different?
Yes.
Great.
Is Ashley Klein?
She was here. I think she just stepped out. I'll get her. She was right here.
All right, we're on the record in People versus Klein, case number 234857. The record should reflect Ms. Klein's present here in the courtroom. What your appearances on?
Yeah, people are.
Kyle Travis on behalf of Mrs. Klein.
Mr. Travis, can you tell me where we're at with this case today?
Yes, Your Honor. We did waive the prelim. We have been discussing the matter with the prosecutor. We do have some tentative offers on the table. But Ms. Klein would like some more time to discuss that with me and think about things. If we could have 30 days and set it for a plea cutoff at that point, I strongly suspect we'll have a resolution, but if not, we can go from there.
Mr. Ziegler.
I have no objection to the attorney.
All right, Ms. Klein, have you had a chance to talk about this with Mr. Travis?
Yes.
Do you have any objection to that?
No.
All right, so we'll set this for a plea hearing in about 30 days. Mr. Travis, I'm gonna set that as a plea cutoff. Seems like, just given the nature of the charges here, should either have agreement or not have one by then. So Ms. Klein, it's important over the next month or so that you stay in touch with Mr. Travis and that you discuss with him any plea offers that are out there. When we're back in court next time, I'll need you to have made a decision about that. So again, whatever you need to do, get that settled in your mind. Okay.
Oh, yeah, thank you.
Thank you. That's all. Next hearing is with Ms. Nichols at 11:30. So Travis, whenever you're ready, you can take that early.
No sentencing for Thomas May?
No, that one's.
Okay, all right.
we're on the record in People versus Krista Nichols, case number 234827. The record should reflect Ms. Nichols is present here in the courtroom today. If I could have counsel put your consent.
Crimes of people, your prior convictions or the 2 prior drunk drivings that make her eligible for the program. They've also occurred very recently in her life, both in 2022, prior to this incident, which took place in April. Taking that all into consideration, Your Honor, I think she's a very good candidate for the program. She doesn't have a long, extensive criminal history. It's clear she has a substance abuse problem with alcohol that's been a considerable problem in her life over the last year or 2. I'm hopeful that she will embrace the sobriety court program and use the tools that are available to her as a result of that program to help turn this issue around and get back on track. So I would ask the court, follow the recommendation, sentence her into the sobriety court program.
Thank you, Mr. Travis.
Your Honor, largely, we would echo that, you know, in speaking with Ms. Nichols, and it's kind of a unique situation. She had just been convicted of her second right before this happened, but she had done well and being honest and truthful and in Grand Traverse, and managed to have them support keeping her on probation, even though this happened, which dealing with the probation over there, I'm sure took a high level of honesty and forthrightness to get them to do that. And Ms. Nichols has been very upfront about what's going on and very motivated that she wants to not drink anymore, that she wants the help. She was very optimistic about the prospect of doing sobriety court from the very beginning. This is not a person who's doing this because, oh, it's my only option or it's better than the alternative. She wants to be sober, very much so. And she's got a lot of motivation for that, you know, and she has young children, and she's doing well in many other aspects of her personal life currently. So I think she'll be a great candidate. I think she's got a very good attitude and good outlook about this, and very hopeful she'll be absolutely successful. Thank you.
All right, thank you, Ms. Nichols. Anything that you wanted to say today?
I would just like to say personally on my behalf, I've been sober for over 200 days now, and counting. And though this has been the worst, best thing to happen to me, it has really helped me gain some clarity and make some really positive progress on a multitude of different aspects of my life. So I would just be very grateful for the ability to continue the progress I've been making, and you know, just be able to do those things and hopefully continue to climb that hill that I've been working on. So.
Thank you. I did read through the report, so I'm familiar with your background and circumstances. Also, you know, what happened in this particular case before the court on this file. And you know, it looks to me like things went seriously off the rail for a period of time there. And there are various reasons why that can happen. The important thing is, I think you probably understand, is how do you deal with that going forward to not get in that position again. From the court standpoint, the sobriety court program is one of the best tools that we have to try and help with that, as opposed to just, you know, putting you on regular probation or putting you in jail. Certainly jail acts as a punishment, but it doesn't really do much to deal with the underlying problem and prevent it from happening again. Whereas the sobriety court program is designed to do that. So I hope you do take advantage of the types of things that are going to be offered through that program to continue working on this as you do use other methods as well. But I think in your case in particular, it's appropriate. I think it's the kind of program that could get you back on the right track, provide you with the avenue to move forward from this, but also provide the community with some kind of assurance that you've moved on from this and aren't going to present a danger by being out on the roads and operating a vehicle in this condition, which is, you know, carries with it a lot of potential serious consequences for yourself and other innocent people who are involved. So I think it's a good program. I think you're a good candidate for it. From what I read and from where you're at this point, I don't see any reason why you wouldn't be successful in it, and I hope that you are. So the court is going to follow the recommendation and sentence you to probation for a period of 24 months. The most important condition of your probation is going to be participating in and successfully completing the sobriety court program. The court's going to adopt all the other terms and conditions of probation. The court will order 30 days in the Kalkaska County Jail with credit for 1 day served. That time to be held in abeyance and served at the discretion of the sobriety court. Court costs of $325, attorney fees of $350, a DNA testing fee of $60, state court cost of $68, a fine of $500, and any costs associated with the participation in the sobriety court program. You do have the ability to seek an appeal of the sentence. We're going to provide you with some papers, Ms. Nichols, that explain to you what the appellate process is if you wanted to appeal the sentence, as well as I request a lawyer to help you with that. And Mr. Travis, if you can just have Ms. Nichols initial or appropriate there.
I'm sorry, let me just clarify. How long was the jail sentence?
30 days. All in abeyance.
And was there a crime with them?
Yes, $130.
Thank you.
All set? Yes. So good luck to you, Ms. Nichols. I hope and look forward to it.
Thank you very much for the opportunity.
Shannon, should I have her come see you?
Yes, thank you, Kyle.
Yeah. Thank you very much.
You're not on the last case. Aguero. No. Okay. Thank you, Mr. Travis.
Thank you, Your Honor. Good afternoon.
You know where Mr. Aguero is?
Your Honor, I would expect he's in our custody in Wexford.
Wexford. Okay. Don't see them connecting yet, so just take a short break. Okay, Ms. Vandenberg, are you able to hear me okay?
Yes, Your Honor, I can hear you.
Okay, very good, thank you. And Mr. Aguero, we're gonna need you to, there we go. Are you able to hear me, Mr. Aguero?
Yes, sir.
Am I pronouncing your name correctly?
Yes, sir.
Okay. All right, we're on the record in People versus Aguero, case number 234860. Should reflect Mr. Aguero's appearing today by video from Antrim County. His counsel, Ms. Vandenberg's also present by video. Mr. Ziegler, on behalf of the people, is present here in the courtroom. This is set for a status conference in this case today, Mr. Aguero's first appearance before circuit court. Ms. Vandenberg, have there been any plea discussions, or can you tell me where things are at from your side?
Yes, thank you, Your Honor. I've had conversation with the prosecutor with regard to Mr. Aguero, and there is an offer on the table. However, Mr. Aguero and I need to spend a little more time discussing the offer, going through all of the discovery, et cetera. I've had some time with him at the H.M. County Jail. I'm about 3 hours away from him, so I did visit with him for a couple of hours, and then again during the when the prelim was waived. Excuse me. So we've had some discussion, but not in depth as we need to. And I'd just like to point out to the court, Mr. Aguero is only 18 years old. And this is a first offense for this young man, a first adult offense. He has one minor record, juvenile record, but this is all new to him. So I just need some more time. I think he does too. He and I have spoken many times over the phone, but have only had face-to-face meeting twice. So I would ask the court to extend, and when I say extend, to adjourn maybe the status conference and set it for another date. I need, again, some more time to talk with Mr. Aguero as well as the prosecutor. Thank you, Your Honor.
Okay, Ms. Vandenberg, how much time are you asking for?
If the court would allow me 2 weeks, that would be sufficient.
Okay, thank you. Mr. Ziegler, do the people have any objection to that?
Your Honor, it's a very serious case and a fairly complicated case. I don't have any issue with an adjournment at this time.
Okay. All right. So Ms. Aguero, or I'm sorry, Ms. Vandenberg, the court will adjourn this and set for a hearing. It'll probably be closer to 30 days. I think my next motion day in 2 weeks is already.
No call.
Yeah.
Excuse
so
me,
I
Your
think
Honor.
we'd be looking at about 30 days.
Thank you, Your Honor.
Okay. Mr. Aguero, did you have any questions at all?
No, sir.
Okay.
No, sir.
Ms. Vandenberg, anything else that I can address for your side today?
And nothing further, Your Honor. Thank you.
Mr. Ziegler?
Wait,
All right, Ms.
Mr.
Vandenberg,
Aguero, I'm sorry.
did you want to have a chance to talk to Mr. Aguero? I can put you into a breakout room if you want.
Thank you, Your Honor. It appears that he has a question and would like to make a statement.
yeah, I was just gonna ask to talk to her, to my lawyer in the separate room stuff.
Okay, I'll put you into a breakout room so that you can speak confidentially. So just hold on 1 second. And then that is all for the record today. So the court will go off the record, and I'll leave the room open as long as you need it for Ms. Vandenberg.
Thank you, Your Honor.
And we're off the record and.
Thank you, Your Honor.
Mertz, I'm thinking Tommy.
It didn't leave.
I'm sorry?
It didn't, I don't think it made it leave.
Yeah, it says we did leave the break room.
He said he was gonna leave it open for however. I think that the court over, ain't it?
It could be.
Cause he said,
I don't know if the judge wanted to go.
yeah, no, that's what I thought we had. He said he was just gonna. He said we off the record. That'd be off for that day, and then.
Okay, you might be right because I took it to mean that he might come back on just to give us a date. He said 30 days, and I wasn't sure if he's going to give us a date today, or he was going to mail.
Yeah, that's why.
Give you a date before leaving, but.
Yeah, I want. That's
okay.
Why
I'll just leave.
Yeah. All right. Yeah, I wasn't trying to hold like.
Okay.
If I knew we had court or something, I wasn't gonna try to keep talking on there or nothing. But all right, yeah.
He said we would take as much time as we needed, but I wasn't sure if he's going to come back and give us a new date, or whether it's just going to be a date in the mail. I think I'll report later on just to see if we have a new date for judgment. Okay, thanks.
All right. Yeah.
Peace on.